this court is duty bound to release them. I'm still talking. Please, I'm still talking. No. Please, I'm still talking. I'm explaining this decision. Please, please just allow me to finish. You'll have your time. You'll have your time, please. You'll have your time. Please sit down. These are decisions of the High Court speaking about violation of rights. And the court even proceeds to say you cannot even now register the charge. In this particular instance, they have been given 7 days. What happens to the violation of rights in the previous 6 days they've been holding them? Unless this court can only cure it by saying, we will take that into account when computing the days. But if we don't, and the court is now aware of violation of rights, then these proceedings must end at this particular point. Because what you have are persons whose rights have been violated by the state and they desire to continue violating those rights. And the court cannot be used to perpetuate that violation of the rights of the individuals before it.
Your Honor, I also wanted to seek clarity at what stage we are in these proceedings, because from what I understand, the criminal procedure is very clear that when you've made a ruling, especially on the same ruling that you are asked to review, you made a final order and you clarified and you even went further and read. Now during the clarification, Your Honor, you've gone ahead and stated that you're now giving directions. I'm struggling to understand that from where we stand, where do we respond? Are we still, at which stage are we in these proceedings? Because from what I understand, we come for a review of a ruling. It has been made final. It has also been made clear that if you are dissatisfied, the best procedure is to appeal. Counsel has gone ahead in the course of you writing your direction. He is still making more arguments. He's gone ahead to mention an authority, which you also need to look at. So I think it would be good to mention that we are not in the right direction as you speak. And the best thing to do is for counsel to package his arguments in an appeal court. I think I needed to mention and correct that, because if we keep on making arguments, I think we'll also come for another ruling tomorrow.
I mean, a court is allowed to interpret its directions and rulings. We are seeking interpretation in light of the fact the ruling has been made. I have not even applied for the court to review. I have simply said, the decision has been made. We are back to the ruling of yesterday. We are seeking interpretation in light of the facts which are there. Those 7 days, we are not disputing the 7 days. We are simply saying, of the 7 days, you've held them for 6. Let's get directions.
Is aware that this is a court of law and order.
So there's what we call interpreting a ruling.
Order.
Interpreting a ruling is allowed. Interpreting a judgment is allowed. So we're asking the court to interpret its directions based on the facts and the decision that has been made. That's allowed. If you are not aware, I'll let you know.
Your Honor, with your kind permission, wish to wholly associate my submissions with my learned colleague, Mr. Sonye. Your Honor, it seems that there has been a breakdown on even how parties should address the court, because Mr. Willis Otieno was making a rejoinder to my submissions, and he introduced me issues: infringement of constitutional rights, of the rights of an arrested person, and we are at a loss as to how to proceed with regards to the new issues which have been raised, which also raise constitutional issues outside Article 25A and 25B, which this court is not clothed with the jurisdiction to entertain. Your Honor, you note that the authority which has been presented before you is an authority from the High Court, which has jurisdiction to deal with infringement of rights of an arrested person.
So the point is that he needed a clarification or an interpretation by the court on the days, and he has cited an authority and made a few submissions. So I'll give you time. I want you to respond to what he has said, just that then the court will give directions. So the issue is the interpretation of the days. When do the days
Your Honor, the state had approached this court under Section 36A of the CPC, seeking an extension of the 24 hours beyond which the respondents should be held, and we had sought for 14 days. The court delivered a ruling yesterday, granting the state 7 days. Your Honor, the submissions of the state is that it was in the court's wisdom not to grant the 14 days, or it took into account the 5 days that the respondents had already spent in custody in granting the 7 days. Otherwise, the court would have been very clear yesterday and said that I've granted 7 days from the time this application was filed, and thus the respondents should not be held for more than 7 days from the time they were brought before you. So our understanding of the ruling that was delivered is that the ruling was very clear. The court took into account the time that the respondents were in custody in granting a further 7 days to the state. And the state had sought for 14 days.
Your Honor, I would need to respond. No, but there's something you have said which may influence your mind. Is mentioning that the court took into account. I mean, that's a very loaded statement. Because in your ruling that you read before us, there was nowhere the court saying, I took into account. Because that presupposes.
So I don't want to put that. I don't want us.
Yes, that I just wanted
go
to.
back and forth. So just leave it at that.
And also I wanted to mention the question of the decision of Justice Apurili. Even if it's High Court, it is binding on this court. So you cannot say that what the High Court said does not apply here. That's why the High Court gives directions to
So I'll
sister
give
courts.
directions after the court.
Much obliged.
Information we place aside there.